Good evening, everyone. Welcome to Grant Thornton's webinar on the biggest reform after GST. That is, the four landmark labor codes have been notified effective 21st November 2025. Along with me today, we have three speakers. Rashmi Sarna, who comes with an experience of 2 decades handling various matters on the people, specifically on the labor law. She has an extensive experience of providing advisory, litigation and compliance services across industry spanning different sector. Then we have Ankur Agarwal, who is a director, again comes with an experience of 15 years plus, working with multiple big firms in the past. He has an extensive experience in handling employee-related matters spanning from tax, social security, labor law, and all. We also have Dr. R.G. Meena, who will be joining us shortly. I think due to ongoing parliamentary session, he has some pressing commitments. He will join us within 15-20 minutes. And by the time he joins us, let us discuss, the key impact areas and some practical insights relevant both for the employers and employees. I think in today's webinar, we would like to deliberate on the key impact areas and to set the context. As everyone knows, the 29 existing labor laws have been repealed with four new labor codes, that is the Code on Wages, the Industrial Relations Code, the Code on Social Security, and the Occupational Safety, Health and Working Conditions Code. The only objective of subsume or repealing these 29 central laws and making new four codes of the government is to simplify the existing labor framework, facilitate ease of compliance for the organizations, and more importantly, promote employee welfare. You can see the data pointers provided on the slide on the right side is in the direction of simplification, where the returns of, in all the 29 different acts, we are required to file 181 returns, which is now required to be reduced to 73. Registrations, you can see from 8 registration to single, from 4 licenses to single. I think a lot of emphasis on making the law as simple as we can. Operational framework for returns, forms and registers, etc. is expected to be in place when the rules are notified by central and state. Now, let me move further to give an overview of all the four codes. As you know, the Code on Wages, Social Security Code, Occupational Health and Safety Code, and Industrial Resolution Code all are effective 21st of November. But there's a lot of doubt, there's a lot of ambiguity in the place in the mind of people. As everyone is aware that these laws are passed by the parliament and got a president approval assent in 2020, which is 5 years from the date of notification. So government, when we met the ministry, when we asked the questions to the government, even when Dr. Meena will join us, we'll ask questions. Uh, then I think the same question comes to everyone's minds. Uh, what is the date? Whether it has to be effective 21st November, or we still will get some more time. How the definition of wages to be looked into, how the PM needs to be contributed, whether grandfathering of gratuity is available, gratuity if someone leaves the organization today, how the gratuity has to be paid, whether till 21st of November the gratuity is has to be paid as on the basis of old definition of salary. Gratuity today has to be paid on the new wages. So these kind of things, everyone has ambiguity on the contractual, workers, core activities, non-core activities, and so on. So today, as we have experienced and seasoned speakers with us, I will ask Rashmi Sarna to, help us uh, help us understand few of the key impact areas uh, and discuss final aspects of the codes. Rashi, over to you.
Thank you, Akhil, for that overview. I think we can move straight away to the definition of wages. I think that is one of the key impact areas and something that has been talked about widely over the last 5 years. Just to give a context over here, the definition of wages has been aligned under the four codes. Existing laws have different definitions for basic, for salary, for wages, which means different mechanism of calculating different benefits. Now, under the four codes, the definition is common. We can see this definition in three parts. First, there is a broad inclusive definition which covers all remuneration, whether in cash or kind. Then there are 11 exclusions which have been specified for calculating wages, on which various social security benefits would be calculated. Out of these exclusions, there is a 50% cap on the total amount of exclusions that would be allowed. Therefore, in somebody's compensation structure, if total of the exclusions comprising of HRA, conveyance, bonus or commission, etc., it it is more than 50% of the total remuneration, the excess amount will get added back as the deemed wage, which essentially means that social security benefits under the codes would be calculated on at least 50% of the remuneration. Deduction for gratuity and retrenchment compensation, this is not covered in this 50% capping. So there is a, in the media and other places, what we here is, in the new definition of wages, basic is capped at 50%. That is not the case. Basic can still be any percentage which you currently have. It is the exclusions which are capped at 50%. Further, any remuneration in kind, to the extent that it does not exceed 15% of the total wages, that will be included in wages. So, therefore, there is an arithmetical manner in which now organizations will have to look at how the definition of wages applies to them. And while computing wages, what we understand, what we have seen over the last few years is there are certain aspects that require more clarity. All of these are very practical questions that we hear. There is an exclusion for bonus, but what about performance bonus or one-time bonuses, which are a common part of our compensation and benefits across the industry? What is included, what is the meaning of the word sum paid to defray special expenses? Now, this exclusion is there in the current ESI Act as well. So same reference has been brought into the wages over here, which, so sum paid to defray special expenses would mean any amount paid exclusively to earn to carry out their activity, and which is inextricably linked to that activity. Similarly, there are other questions as well, which is how do you quantify benefits? How do you determine whether the ESOPs or stocks, these are, whether they are part of the remuneration or they are outside of that? Further practical questions around whether wage determination will have to be done on a monthly basis or on an annual basis. So a lot of practical aspects are there with regard to wages, which organizations have to review in the context of their compensation and benefits, and what interpretation or what treatment has to be considered for those.
Thank you, Rashmi. I think that gives a lot of clarity with a lot of still ambiguity around it. But I have few questions around the topic for better understanding for audience, and I'm glad to see that more than 1,000 people have already joined, and we all are waiting for Dr. Meena also to join us. Just out of the context, Arushi, if you can see, there are many clients who are sending a request; they're not able to join because the capacity is showing full. I don't know if you can make it right. Coming back to this, actually, how would variable pay be treated for the 50% wages cap under the code? If you can clarify on that, please.
Based on discussions, based on our understanding, Akhil, variable incentives which are linked, which are one-time bonuses linked to any skill or any targets or any performance, those are not part of my regular remuneration. And in our view, the variable pay of this nature would be excluded, would be outside of the remuneration with which we start, from which the exclusions are to be considered. So therefore, if my agreed compensation is say 100, and the variable amount or a performance linked bonus or a joining bonus that is above that 100, then that amount is not considered for calculating the 50% wage gap under the code. This is the understanding that we have received, and of course any further actual clarification in the form of an FAQ or something would be certainly helpful for the industry to take this position into their payrolls as well.
Understood. Understood. And what would be the practical valuation mechanism for benefits in kind? Because as I was hearing your definition on wages, we talked about, benefit in kinds as well. How practically the valuation will happen? Because in income tax law, there's a different way of computing the value for the benefits given to the people. And this code on wages, or code on social security or any rules, is there any way, this is bit defined, provided for?
Good point, Akhil. So while there is a 15% that threshold for benefit in kind, however, the term or the phrase benefit in kind is not defined under the Code on Social Security. Absolutely rightly mentioned that under the income tax rules, there is specific valuation mechanism provided for a host of benefits, and that has been the practice followed consistently across the years. For now, for the Code on Social Security, for considering the benefit in kind, the practical approach to be taken would be the value, the cost of such benefit to the employer. That can be a thumb rule right now, in the absence of any further clarity. Again, another aspect which for which industry at large would be benefited if there is a express FAQ or a clarification that we receive.
Understood. Understood. Maybe we'll have more. We'll ask this question again to Dr. Meena once she joins and to have more clarity on this. But thanks for your valuable input, Sashi. And I'm sure the government would incorporate some of these aspects by way of formal clarification or FAQs in due course. Now, if you can take over some of the key areas around PF.
Right. Thank you, Akhil. So as per the notification which came into which was in the official gazette on 21st of November, the existing EPF Act has not been repealed, and also the government has been enabled to frame the schemes for EPF, EPS, and EDLI. What this means is eventually the EPF Act would be subsumed into the Social Security Code, but the transition is pending because detailed rules, the guidelines, and the scheme are still awaiting finalization, or they have to be framed, put in public domain, and then notified. So once these are notified, employers and employees would be complying with the PF schemes and provisions, PF, EPS, and EDLI schemes and provisions. Also, under the new codes, the present wage ceiling under the Provident Fund contribution, which is 15,000 per month, would still continue until and unless any change is notified in this by way of the scheme to be framed or in any other manner. Also, to our understanding, pending the scheme to be framed, pending the notification of rules and other regulations, the new wage definition or the new provisions as per the code may not have any impact on employees who's drawing salary or wages above 15,000 per month, because this is also a very practical aspect which has coming to us from a lot of employers, because in the industry there's a mixed view taken. Some companies calculate PF on the wage threshold of 15,000 per month, but some companies calculate PF on the actual basic salary, which may be well above the 15,000 threshold.
Thank you, Rashmi. I think well noted. But before we move to another topic, let me ask few of the questions which our audience would like to see clarification. So, in case an employee drawing wages more than 15,000 per month, would there be any impact on the PF contribution due to change in definition of wages?
Akhil, in my view, there won't be any change, because as the obligation or the requirement under the current legislation also, the mandatory part is where the contribution by employer, where the wages up to 15,000 per month. So we have a lot of companies where the PF contribution is 1,800 rupees per month, which is on the 15,000 threshold. So in all such cases where
Correct.
the employee is drawing higher salary, there would not be any impact.
So if I flip this other way, if less than 15,000, if as per the definition of wages, the wages are less than 15,000, and I can understand that the limit of 15,000 will continue. So for them, it's a mandatory to contribute. So they have to contribute as per the new definition of wages, right?
Yes.
So there's no ambiguity. This is very clear.
Yes.
Perfect. I think that makes sense. Thanks, Ashley, for your valuable time and inputs. Let me now request my another speaker and colleague Ankur Agarwal to discuss over the key important changes around classification between worker and employee and impact of labor code on the contractual workers, because this is very important issue which industry at large want to understand. And just to give a perspective for everyone benefit, what we have tried to do, we've divided the entire discussion into two parts. One is an operational implications where we'll talk about these things, and one is a financial implications which has a direct impact on the P&L of the employers and take hand for employees. So to make it more relatable and interesting, so this what we've tried to do. I know a lot of people have a lot of questions. We've already got 50 questions, but will what we do, we will try to sort them out and start asking these questions to Dr. Meena once he's joined us. He's about to join anytime in 8 to 10 minutes. So Ankur, why don't you quickly take us through, changes around classification between worker and employee and the impact of labor codes on the on the contractor workers. Thank you.
Sure, Akhil. Thanks a lot. And with regard to questions, I would just like to add, by the time we finish, we hope that most of your questions will get addressed. But let me start with the employee versus worker analysis. A concept of worker has been introduced in some of the labor codes, and I would like to clarify that the concept is not a new concept at all. It's a concept which has been there since ages. So there is a concept called workmen under the Industrial Disputes Act, and very similar definition has been considered under the labor codes. Now, what is changing here? What used to happen under the Industrial Disputes Act, if there was an industrial dispute, then a post-mortem analysis used to happen that whether this employee will classify as a workman or not. If he was a workman, then he was entitled for certain benefits such as retrenchment compensation and so on. Otherwise, the regular employees were not getting that kind of benefits. So the same concept has been taken in the new labor codes, and that becomes applicable for all the industries. Now, the significant change here is that there it was a post-mortem analysis. Now it is an ongoing analysis, or rather, you have to do this analysis in advance, because some of the entitlements which your workers, the employees who will be classified as workers, will be getting, such as leave encashment or overtime, that will be paid on a month on month basis or on regular basis. And then at that point of time, you can't do a worker versus employee analysis. You have to do this analysis in advance. So that's the shift in the mindset, or shift which the law expects the industry to do here. So in the transition journey, migration journey, this is one of the analysis which has to be done along with other aspects like what Rashri covered, a compensation structuring may be required. Now there is one issue in classifying employees as worker or non-worker. So the language of the worker, or the definition of worker, is very broad. Very less carve-outs are there, and someone who is having a managerial role or or an administrative role, irrespective of the salary threshold, will not be worker. But if you are not having a managerial role or administrative role, and whatever salary you get, typically a independent contributor kind of role, you can become a worker. And once you become a worker, you will be entitled for a lot of benefits under this code. So accordingly, this analysis is a very, very important analysis. You can go next, Pooja.
Yeah, so Ankur, before you move to the impact on contractual workers and arrangement, I have one or two questions for you,
Please go
with
ahead.
interest of, because I can see a lot of questions coming around this. So it is now expected that each organization, irrespective of sector, is required to classify employee into workers and non-workers. What's your
That's right.
take on this?
That's right, Akhil. So OSH code categorically states that irrespective of sector or industry, if an organization has 10 or more workers, right, then the code becomes applicable. and then the all of these provisions would get equally applicable. In the current regime also, although the law was called as Industrial Disputes Act, it was an extension. The way industry has been defined, everyone gets covered there. Whoever is doing business gets covered there.
Perfect. I think that gives a lot of clarity. So, Ankur, now you can, guide us on few of the other aspects around contractual workers as well.
Sure. So very very important point, and I would say less very less hyped in media. So you will not find a lot of discussion around this topic, impact of on contractual workforce, in media articles. What you will find on the other aspects, but very less has been spoken about. But when we are talking to manpower companies or a lot of companies where the business model is through contractual workforce, they foresee a significant change which is going to happen. There can be a disruption in the way people used to work in certain sectors and certain industries. So what are some of the key areas which can impact you? Now there is an express and blanket prohibition of deployment of contract labor in core business activities. So core business activities very broad, very few carve outs are there, and some of the activities such as housekeeping, security, packing, unloading, loading, unloading, and so on, these activities are considered as non-core activities. Otherwise most of the activities will fall under core activities. So this is one of the area where the organizations which are heavily dependent on contractual workforce need to relook into and redefine your strategies around manpower composition in the organization. Second, and very significant change which is going to come, at least reading the language of the law, it is very clear that the contractor has to pay the contractor has to be paid by the principal employer within 7 days of the month end. So if you are availing services of a contract worker, earlier you may be enjoying a credit period of 2 months to 3 months, but now once you avail the service after the month end, within 7 days the payment has to happen. And that could be a significant change in terms of working flow, working capital requirements, as well as renegotiation of your commercial contracts, what is there with the third party vendors. Now in terms of statutory bonus and welfare obligation, again there is a significant and paradigm shift which is going to happen. So far the law was very settled. There are high court judgments which says that principal employer is not at all responsible or obliged to pay statutory bonus for contractual workers. The obligation somewhere varied for provident fund and ESI kind of liability. Now the law has created a specific obligation on principal employer to provide a statutory bonus, to honor the statutory bonus liability if the contractor fails there. So accordingly, adequate ring fencing in your third party contracts have to happen around these obligations. Along with that, so far for the welfare obligations, right, such as drinking water, other facilities, toilets, first aid, etc., this was always the responsibility of contractor and not the principal employer. Now the onus and the responsibility has completely shifted to principal employer, and these are some of the fundamental business models or business triggers which has to triggers which will impact your business model.
So, so Ankur, what I can, uh, take from whatever points you've just highlighted to the people at large, that earlier it used to be the contractual responsibility, but now as an employer, principal employer, you have to ensure that these benefits, these facilities are provided to these to the contractual workforce, or you have to provide this at your own level. That's my first question. And if as a principal employer you have to take care of these, the cost, the P&L will have a significant impact. What's your view on this?
Definitely, Akhil. So the law has passed on the obligation to principal employer for some of these responsibilities, and it will have some cost impact, incidental cost impact, at least at the time of transitioning. A immediate hit or impact will be visible, and once it becomes business as usual over the period of time, it may get absorbed. But as of now, the cost impact will come, and at the same time there will be a need for all sort of ring fencing between both the parties. So both the parties have to be very clear about what is changing. So both the parties are equally concerned, Akhil, when we talk. So the organizations which are providing manpower are concerned that the business model itself is at risk. People who are running the business through contractual workforce, they are also worried that things may change drastically. So this is the area where people have to start thinking and making appropriate changes as required by the law.
Fantastic. Thank you, Ankur. As well, if you could take us through other operational aspects impacting industry at large due to these changes, that would be great. Before we go back to Rashri and discuss more on the financial implication.
Sure. Sure. So one of the area or concern, right, where we are getting a lot of queries is whether a shops and establishment act will be there or it will be repealed. On a lighter note, I say that both are siblings and they have to coexist with each other. There will be fight between them, but a harmonious construction has to happen so that both live together and happily. So shops and establishment used to regulate the organizations which was not governed by Factories Act. That's how it has worked so far. Now, along with that, a lot of provisions, there is a overlap with labor codes. There are provisions for working hours, overtime, leave encashment, and so on. So labor codes has overlapping provisions. In some of the states, it may tie with the central rules, the state rules on central codes, right? As well as in some states there may be a difference. So both has to stay. So whatever provisions are beneficial, you need to read the laws together and ensure that the employees get the best of the world. At the same time, what is important here from an organization perspective, this is going to impact all your HR policies, payroll policies. So you need to relook into your HR policies and ensure that they are getting aligned with the new requirements. First, they need to align with Shops and Establishment Act, that continues, and along with that, whatever new requirements are coming, it has to be aligned with that as well. Another important and very interesting aspect, Akhil, I want to touch upon is that in case of multi-state presence, right, so there is a view which comes out that different state rules also may be applicable, and then a harmonious reading of multiple documents will be required to arrive at a single unified policy if organization is looking at. Second very important aspect which is coming out, and a big industry concern is that full and final settlement has to happen within 2 working days, right? Again, this is not a new concept. This concept was always there in cases of retrenchment of employees or termination of employment, but for voluntary resignation, this is something which has been extended now, and 2 working days is the law right now. How we can what we can do to achieve that is something we have to arrive at. How the IT assets can be recovered within 2 working days. So there it's a journey. The law will evolve, practices will evolve, but as of now what I can say is that there is a process you start after last working day. That same process you may start once the employee puts down the paper, and you have to see how your internal processes can be re-engineered to save some time in this entire settlement process.
Ankur, I think one question from my side, when because you talked about that shops and establishment and central laws, there's a lot of overlapping between the provisions and all. Do you think that whatever provisions where the overlapping is there would get repealed in the due course? Do you feel that?
So ideally that is what states should be doing in due course of time. Either they should align the provisions in the Shops and Establishment Act with the requirements of labor codes, or at least they can have those provisions which are overlapping to be repealed in due course of time. Complete abolition of Shops and Establishment Acts looks very difficult, Akhil, because there are a lot of provisions which are overlapping, but there are provisions which are not overlapping also. There are other matters which are being dealt by Shops and Establishment Act. So it will be there, but we all of us as an industry, we expect that some sort of repeal or alignment happens for the overlapping provisions.
Understood. And Ankur, as you rightly said, within 2 working days of exit, clearances of dues, there's a concern on the recovery of assets, and calculation may not be possible. So, I believe, I don't know whether this is a right interpretation to take or not. You can clarify as an expert that the two is like 2 working days from the last date of the notice period. If a person exit, apply, file a resignation. So we have 3 months or 2 months notice period which we've generally seen. So that's an ample time which government has already given to the organizations to prepare and ensure that from the last date of the full and final settlement, it should be paid within 2 working days. Don't you think that's an ample time, or do you think that we should have some other way around it?
No, no, Akhil, there is a ample time. It is more about, re-engineering your existing processes. Because
Yeah.
if law was always there to settle it within 2 days, that is what would have happened, right? It was not there earlier. It was not governed by strict rules. So that's why there was a 30 to 45 days of window which organization used to take. So some rearrangement there. Obviously, asset recovery is a big challenge. For that, some clarification from Labor Ministry will be welcome, because then you have to withhold some of the amount, right, for asset recovery. So the practical side of it, it will evolve. The practices are going to evolve as in when we move ahead in this journey.
Yeah, I agree with you because it's been 20 years, 2 decades when this journey has started. And when this law was written, they were not aware about COVID will happen or work from home or hybrid working will
Right.
happen. So that's the reason this asset recovery in 2 working days is practically impossible. Thanks for your time and giving your perspective. Now I would request Rashi to throw some light on other financial implications for the employer.
Right. I think in terms of the financial implications, the very first point is gratuity, because provisions for gratuity have been there in the company's books. That is something which the accounting standards requires us to take. Provision for gratuity is put together based on the current definition in the Payment of Wages Act. Whereas in the Code on Social Security, with the change in definition of wages, the wage amount will most likely be higher than only the basic in most organizations. Hence, there is a impact on the quantum of gratuity that would be paid to the employees. Before we come to some practical aspects over here, just to outline what the new provisions are going to be. Uh, First and foremost, there is no change in eligibility, which is still 5 years time for permanent and regular employees, for where there is no end date to their tenure. So 5 years or exceptional circumstances like death or disability, those provisions still remains. One of the key change is in terms of applicability of gratuity to fixed term employment. Now, fixed term employment, which is eligible for gratuity here, means where the services are rendered under a contract for a period of 1 year or more, like a 2 year contract or 18 months or 24 months, and so on. In this case, the completion of continuous service of 5 years will not be applicable, be required. Now, in case of an employee who's on a fixed term employment, the employer will be paying gratuity on a pro rata basis, even if the contract ends earlier. So, if it's a 2 year fixed term contract, if the contract ends, say, in 18 months because of the project completion or any other such reason, then also the eligibility for gratuity would be there, and it would be calculated on a pro rata basis. Now here, Social Security Code also defines the fixed term. In terms of fixed term employment, there would be a proper contract. The contract would mention the end date, and based on that, that's how we differentiate between what is a fixed term contract employment and a permanent employment. And this is not to be confused or mixed with consultants or such independent consulting or contract arrangements which companies have with individuals. Those could be consulting contracts with professionals or others, which is essentially not an employer employee relationship. So those arrangements which are consulting or contract in nature and outside the employer employee relationship are not considered as fixed term employment. Fixed term employment is the regular employer employee relationship, but with a fixed term of engagement with that entity. So, hence, I think employers where now we see a lot of fixed term contracts also. So, that is something you would need to review and make necessary changes or bring in that gratuity provision for the fixed term contracts as well.
No, I think that's very useful information for everyone, and I have a lot of questions on that. But I'm waiting for Dr. Meena to join back. I don't know whether he's joined back, though he's connected still, but his video is not visible. So I'm waiting for him to join back and have questions to him on this instead. Thank you, Rashri, for the clarification. This will certainly help the organizations to comply with the law. Now I will ask Ankur to talk us through the changes in leave encashment and overtime provisions. Uh, can you also quickly cover that before we'll have
Sure,
other questions and waiting for Dr. Meena to join?
sure. So in general, overtime is a payment which is applicable when someone works beyond the normal working hours. Normal working hours is defined today, also it is defined under Shops and Establishment Act. It has been defined under the labor codes as well. Now we find reference of overtime, one in OSH code, other one in code on wages. What OSH code says that it is applicable to workers, and what code on wages says that employees for whom who are covered under the minimum wages, they will be entitled to overtime. That's a bit of anomaly in the language, or at least in the interpretation, considering the fact that going by the various documents from the government, what has been stated that under the minimum wages the concept of scheduled employment will not exist now, which typically would mean each and every one who is employed will be covered under minimum wages. So what is the relevance of having that wording there for employees who are covered for minimum wages is something where a ministry has to come with some clarification. But at the same time, what is very clear by the law is that if you classify someone as a worker, right, a set of your employees who will be classified as worker, they will be entitled for overtime payments, and overtime payments has to be done at twice the wages. There are adequate rules around that. What is a normal working hours, what is how many hours of additional work someone can do, what will be the total overtime, what can be done in a quarter, in a month. Respective states have different rules. For example, the rules of Haryana are very flexible. A lot of inbuilt flexibility they have introduced, wherein people can have flexible working hours with they will work more on few days and some of the days they can take off. So that kind of provisions exist. Once we have clarity on the other part, the point on code on wages, the one part of the non-worker part will get clarified, and workers, the overtime mechanism has to be introduced considering the strict enforcement, the penal provisions in the new labor codes. You need to have policies around that and the enforcement mechanism to calculate overtime hours. And
Ankur,
there are
Ankur, before you go
yes,
to the concept of leave encashment, I have one question on the overtime. If you don't mind, I ask you, or maybe once you finish, I'll ask that.
please go ahead, Akhil.
Yeah, yeah. So I think regarding overtime, the code provides for overtime to employees who are covered for minimum wages, as you rightly said. However, the concept of scheduled employment for minimum wages has been removed. So does this mean that overtime may be applicable for all the employees now, even for us?
Yeah, that is one of the view which comes out of it. But I would say this is an ambiguous area. The position is still unsettled, but at least for one class of your employees it has to be paid. That is very clear. So what can happen there? Even though scheduled employment is removed, the government will still issue notifications for minimum wages, and how the law evolves, all of us will be witness to that. But if there are a category of employment which will be mentioned there, then a view can be taken only uh, those categories which are mentioned in the notification gets covered here. Only other point which I want to cover here is that overtime reference comes in Shops and Establishment Act, it comes in OSH code, it comes in code on wages. So again, a harmonization, a constructive reading of various documents read with the respective state laws is the need of the hour. We need to understand that. We, yeah, okay. We have sir with us, so
Yeah, yeah. Thank you, sir. We can understand
Yeah,
the pressing commitments you have. And I think the audience has been waiting for you, and you've joined at the right time when we've concluded all our slides. Now we have all the relevant questions for you.
okay.
But before coming to that, let me give a quick introduction about you to my audience. We are honored to have Dr. R.G. Meena, who is a former Deputy Chief Labor Commissioner and advisor to the Ministry of Labor and Employment. Dr. Meena has been involved with the ministry in various capacities over his more than 3 decades of experience. That's something commendable, sir. As everyone should be aware of that, he was instrumental in framing the labor codes and has deep insights into all aspects of this implementation. Sir, we are grateful for your presence and we are looking forward to receiving your guidance in today's session. As you know, today we have assembled to discuss about all the four codes. So without wasting any time, and I know due to ongoing parliamentary session, you have a pressing commitments and all. But thank you for taking time out for our audience. Now, can we have an overview from you on key impact areas such as wages definition, benefits like gratuity, PF leave encashment, provision for contract workers in core activities, guidance on notification of rules by center when the rules by center will be published and state for that matter, and roadmap for the organization for smooth transition to the new labor laws. I know I've asked you for, but I will repeat. But these are the things where we can get an overview, and then there are some specific questions. We'll come to that.
Right. Okay. Thank you very much. First of all, I feel my apology because it was scheduled at 4 o'clock and there were government exigencies, and I have no excuse but to attend that meeting because 3 calls came from my apex level in bureaucracy. Anyway, friends, so I'm also a human being like you. It is nothing special. We all learn every day in our life. So I got the opportunity to draft the code. I was a technical member and deeply involved in drafting all the four codes and drafting the rules also. I was a member secretary for the drafting the rules also. Briefly, I will touch it. I know because after notification on 21st, everyone is eagerly reading the codes. Before that, I can tell you, very few people have read it. The draft rules were in public domain earlier also in 2020 and 21. We have received very limited objection and suggestions, which has been examined and incorporated in the codes and the draft rules. So friends, the code on wages, just briefly I will introduce you so that you should have a fair idea about the code. Code on wages basically subsumes the wage laws, and now we will have a universal minimum wages. This may be noted because every category of employee will be covered under the minimum wages, code on wages. Then we have to make payment on or before 7th. Earlier, the flexibility was there up to 10th, where the 1,000 and more employees were there. Then first time we have brought the statutory floor wages. This will balance the regional imbalances. No state government can fix the minimum wages below the floor wages. So it will balance the border states. Then we have made the employee definition very simple. So in code on wages, the employee means skilled, unskilled, semi-skilled, highly skilled, managerial, supervisor, all are employees. Most importantly, the threshold of 24,000 has been removed and there is no, as of today, wage ceiling for definition of employee. So every employee will be covered except the employers who are covered under the definition of employer. So code on wage again prescribe the provisions for the bonus. We have brought earlier, there was a provision for equal wages for equal work for women, but now we have brought the gender equality. So this is another reform we brought it. There cannot be a discrimination in the recruitment and payment of wages to the all the genders. So we have recognized the transgender also in the new codes, which was not there earlier. So first time we have brought that improvement notice. because till now, if any establishment is inspected, the inspector is issuing show cause notice to you, that is following the principle of natural justice. But now we have brought the amendment in the law, and it is mandatory for the inspector to give show cause notice to you, and you get 30 days time to comply. And once you submit the complaint, then he will be duty bound to verify before taking any further legal action, which was not there at present. So that is the difference, because earlier show cause notice was given, but it was the discretion of the department or the inspector whether to give you opportunity or not. But now, if you have submitted the compliance report, I would request all the friends, whenever any inspecting authority is visiting to your establishment, if he is giving show cause notice, you get 30 days time, mandatorily comply it, ensure that reply is reaching to him. Now we are coming in the portal era, so all the inspection report and everything will be online through portal only. Now inspector will be inspector come facilitator. He will have a two role responsibility. Number one is for the guiding to the employer how to comply and make aware the workers about their rights created under the law. So thirdly, friends, in the code on wages, in the first offense, the imprisonment provision have been removed. Only penalties are there, and that too also compoundable. Now compoundable will be, if it is a repeated offense within 5 years, that will not be compoundable. In the first inspections, if you have failed to submit reply or something not complied, then again when matter is going before the authority or the court, you have one more option, you can go for the compounding. I want to explain you must have seen the Motor Vehicle Act. Whenever you are crossing the red light, you get a SMS message or the WhatsApp message on the mobile, you have violated the traffic rules, this, and if you want to compound it within 60 days, pay 1,000 rupees. Otherwise, a challan will be filed in the court, and then court will take cognizance of that. So this is a big reform we brought after 75 years in the labor laws. And this provision is there common to all four codes. So friends, improvement notice, decriminalization, and compounding has come part of all the four codes. Now, next coming to Occupational Safety, Health and Working Conditions Code. So I am not mentioning which are the laws have been subsumed. In brief, 29 labor laws have been subsumed in 4 labor codes. So instead of listing out the name and all, I don't want to go into that. I'm aware you are mostly concerned about the issues related to contract labor, what is the core and what is non-core. But briefly, I will tell you, OSH, we have been a big reform. In place of 8 registration, there will be a single registration. In place of 4 licenses, there will be a single license. License under ISMW is done away. Factory, PD cigar, and contract labor. Under contract labor, again, we have make a provision. Any contractor want to have an all India license, for example, any big organization, HCC or the LLT is working in more than one state, even in the state sphere, they can obtain license from central authority. So their officials are not required to visit some 10 licensing authority in the state, and the central will issue the license. Thereafter, the rest of the compliance will remain with the state government. So that will make ease of doing business to them. In the Occupational Safety Code, the standards at present are varying from state to state. I am aware, I worked in Mumbai for 5-6 years. I was in charge for the Maharashtra also and Nagpur also. Then I was in the Gujarat. Then I worked in Rajasthan also and Delhi also, Chandigarh also. There were 5 states under me. So each state is having different standards for the factories, plantations, etc. So now that was the call. And when we were drafting, we have a detailed discussion on that. So now standards will be uniform across country. For the factory, for the docks, for the mines, for the plantation, for the building construction. So these will be common standards across. Similarly, you must have read section 23 and 24 of the OSH code, which prescribes the detailed provision for the health, safety, and welfare. These rules will also be drafted and finalized by the central government only. So that welfare facilities should be across countries similar, because working conditions are similar. So that there should not be any variation to that from state to state and all. So this has been a conscious decision by the government of India, and we have already put the provision in the law, and the draft rules were just 3 months back. We have published in the public domain. Suggestions have been received, and we are scrutinizing that. Similarly, in place of 84 registers, now only 8 registers, and that too common to all 4 courts. There were approximately 31 annual returns now subsumed in only single return. Annual return will be only single. I told you inspector is again inspector cum facilitator in the OSH also. Compounding is there. Improvement notice is there. In the OSH code, there are certain provisions which are serious in nature of the violations, like related to safety or any fatal accident, serious bodily injury and all. In those cases only, if punishment is more than 1 year, those offenses will not be compoundable. The rest other provisions will be compoundable in first offense. In the code on wages, I told you the subsequent compounding will be after 5 years, but remaining 3 codes subsequent compounding will be after 3 years. So this is a difference. We have taken a further review on that. So compounding will be in 3 codes after 3 years. Similarly, friends, now come to Social Security Code. Social Security Code, we have combined the provisions related to PF, ESIC, gratuity, maternity benefit, employees compensation, etc. The most importantly, the definition of appropriate government is universe and common to all courts. So earlier, for maternity benefit act, the appropriate government was state except the mines and circus. Whereas now, and the payment of gratuity act, establishment having branches more than one state, central government is appropriate government. So friends, be very clear about that while working as a controlling authority or the appellate authority. I found that sometimes due to lack of knowledge or whatever reason, applications are filed at the state authorities, and when subsequently objection is raised, and they are coming to the central authorities. So definition has been retained that establishment having branches more than one state, the central government will be appropriate government for gratuity and maternity also. So PF and ESIC, you know, it is a central agency only. So for PF and ESIC, only central government is appropriate government. There is no concept of state government or appropriate government. So Social Security, again, benefits have been retained. Big reform we have brought in the definition of family. So Rajshari is here. Now in the code, your mother-in-law and father-in-law will be included in your family. They can get the treatment under ESIC. So that is the reform we brought it. And similarly, so many reforms we have brought it in that Social Security. There were a lot of litigations that when you are coming to the office duty and from office going back to the house, if any accident take place, this will be during the course of employment, and your family will be eligible for the compensation or whatever the Social Security benefits are there. First time we have recognized the gig and platform workers. Friends, let me tell you, when we were drafting, we have searched the entire world, and India was the first country to draft the code and bring in the main law the provisions relating to gig and platform. Only USA, 2 states, one Florida and another, they were having the state legislation, not the national law. After the law was enacted, Honorable President assented, and it was published in the public. Thereafter, because draft rules were there, and there were various aspects, so code have been now implemented. But India, that time, India was the first country in the world which has national level make the law on gig and platform workers for their welfare, social security. Now, to my knowledge, around 15 countries have their law on the gig and platform workers, and some states have also notified their law because central was little late. So, friends, similarly for the unorganized worker, also government has make a provision for the board and the schemes and all, and detailed schemes, their benefits and all is provided in the code. I am not going much discussion on that. Then industrial relations code.
Yes,
The
sir. Yes, sir.
method-
You can continue. I think, in interest of the time, if you can, quickly, then because we have four, five
but no,
questions.
just 2 minutes I'm taking because
Yeah, yeah. After that, we
over
have
an
we
idea.
have we have three, four questions which needs your attention,
Yeah.
and
Please,
then we
just
can have your
bear with
concluding
me just
remarks.
2 minutes.
Yeah.
So, Industrial Relations Code appropriate government definition is almost similar to the Industrial Disputes Act. We have added the metro railway, and another reform is that any public sector, if their stake of central government share is reduced from 50%, then also central government will continue. Number two, strike notice is made mandatory for all the establishments, which was earlier in the case of public utility service only, 14 days. Thirdly, whether you have notice or not, now the conciliation proceeding will start when the first conciliation meeting will take place. In the existing law, once the strike notice is received by the conciliation officer, conciliation proceeding deemed to have been started. But now, after the first meeting, so that responsibility lies with the conciliation officer also. And I would request all my friends, be aware whenever any such notice comes, forward it to the conciliation officer and ensure that he is issuing conciliation notice before the date of strike, so that matter is seized in conciliation and your industrial peace and harmony is maintained. The moment conciliation proceeding is started, then service condition has to be maintained same, so strike union cannot resort to strike pending conciliation. Okay, friends, the rest of the provisions are the similar. I am not discussing on that. Now coming to Akhilji for your
Yeah.
question.
Thanks, Dr. Meena. I think very insightful for last 10 minutes. You were, the way you were throwing the provisions and all looks like the kind of hard work and the kind of hours or years spent on this. And it has been inclusive, whether it's gig workers or unorganized sector or platform workers who has been taken into. Even you've talked about transgenders and things on core activities but few things we want to have your view, and if you are not able to give the view, it's okay. I can understand, sir. As you know, because of the change in the definition of wages impact the retirees the way it should be, because as everyone knows, before this no code on wages, or definition of wages, there were different base salary which were considered in different acts. But now there's a uniform definition of wages which has to be used, and it can impact the retirees. So can employers undertake a compensation restructuring so that compensation structure is aligned with the new definition of wages? Is this okay? If the people can restructure their salaries internally?
See, we have a discussion in the law ministry also. Code have been notified on 21st of November.
Yeah,
So definition don't have any rule making. So what is the understanding given, as you must have read the PIB press release also,
yeah,
there is always a transit period when any new law is coming and the old laws has to be repealed and all. So
yeah.
this is the period where the transit period is going on. So there are provisions in the General Clauses Act also and the other parliament matters also. So those sections which have no bearing of drafting any rules have come into effect.
Okay, understood.
Okay, so that is very clear. Definition of wage, you must have read it, because remuneration, then basic, DA, and retention allowance, and the rest of the allowances A to I, 50% and above will be part of wages. Okay.
So the interpretation I can take, as you rightly said, this is a transition period, and people, if they want to do changes in the way the payroll looks like and the things
They
looks
can
like,
do it.
they can do it. Thank you very much, sir. And similarly for gratuity, because a lot of people have this thing in the mind that we are sitting on 2nd of December. If someone leaves, and as per the law, it has to be the last on salary or last on wages as per the new code, but the provision has been created in the books till 21st of November or till date also, and there are a lot of listed companies who are closing on 31st of December. They have been creating a provision as per the salary. So how they should look into it, but I think you clarified it's a transition time and central rules will get notified, and then that's how the methodology of doing it, grandfathering, not grandfathering, that clarification will come in due course. That's the right way to look into it, sir.
See, for gratuity, the provisions are very clear. because we have to calculate the gratuity and eligibility criteria. You are aware, 5 years of continuous service.
Yeah.
One point I want to clarify you for the benefit of all. If any employee completed 240 days in the 5th year, he will be eligible for gratuity.
Yeah.
So kindly take care. I, as an authority, I dealt a lot of claim cases. More than 1,000 cases I decided. So all variety of questions comes sometime. So that part you should take care. Fixed term employment, we have brought the gratuity proportionate on completion of 1 year of service. For consideration of 1 year of service, 240 days has been kept in the Social Security. But one major difference I want to highlight you, for the calculation of earned leave, the eligibility has been reduced from 240 to 180 days. If an employee has worked in the calendar year 240, in place of 240 days, 180 days, then he will be eligible for earned leave on 20 days attendance, one earned leave. So that is the difference. Then calculation method and everything we have written same, because this is a social welfare legislation, social security legislation, and there was no need to give any further amendment except the definition of wage. So the employer has their own teams, you have your management teams and all. So calculation has to be on the basis of last round wages, and wages has been defined in the law, and wages has no bearing of the any rules making. So law ministry has very clearly categorically mentioned the provisions which have a rule making shall be effective when the rules are finalized. It will be the government decision whether those rules will be effective from 21st November or from the date of final publication in the Gazette. Okay. Yeah, next please. Now,
Yeah. So, sir, one more thing, but on the grandfathering or something, there any FAQs which are in the pipeline?
yes,
Or-
yes. See, we are continuously engaged. Let me tell you, friends, we have prepared the background note for every aspect, pros and cons, and not cons much, but the benefits of the code for the employee, for the employer. And we are answering also, and FAQs are, we have already drafted, finalized it, and more FAQs will come. So I would request you, whenever you are getting any such FAQs and all, please forward it. There is a dedicated team here. So we will clarify it so that it should go very smoothly and there should not be any doubt and all these things. So that is the reason today I'm sitting with you.
No.
Yeah.
Thank you, sir. Thank
Nation has to go on board.
No, sir, we are very much with you, and I think this is very encouraging. Everyone has accepted this as a change. Post independence, something has happened on the labor law, and biggest reform in that area. I think the government has worked for 20 years, so very welcoming. And sir, last two questions before we conclude the session for today. As we talked about, contract workers in the core business is now prohibited. You talked about that. And under current laws, only Andhra Pradesh has a similar provision as a state. We think establishment would need time to review and change the manpower composition, because there's a lot of outsourcing and contractual labor, and a lot of organizations, especially in manufacturing, has been using the contractual worker for core activities.
Good.
So your view on this, sir, your thoughts on
No,
this?
I am fully aware. Let me brief you the entire audience. I begin the career from Mumbai, and after selection by UPSC, and when I was posted there, there were around 400 writ petitions relating to contract labor, and 80% were regarding prohibition of employment of contract labor. So I dealt it. I know the subject, and because in the existing law there was a concept for prohibition of contract labor, there was a tripartite board, and that board will study and recommend it, and government may prohibit any employment which is a perennial nature, etc. And we are aware about it. See, you may be aware, Government of India has prohibited sweeping, cleaning, and watching of the building in the central government way back in 1976. That notification was valid till 2001, when the sale judgment Honorable Supreme Court says that now time is changing. We cannot force the establishment for such subsidiary services to engage the permanent employees. Okay, so and then thereafter there were a lot of judgments of the various high courts and honorable Supreme Court. We have studied what you have mentioned, the Andhra Pradesh. I got that opportunity to examine in 2002 when the Andhra government has drafted the bill for the state government, and then we have discussed, we have in fact brought that copy also, and broadly provisions we have taken it. So now core and non-core is clearly defined, no doubt, no dispute, and no establishment should be panic that we should go this way or that way. Your all system will continue. We, while defining the perennial nature of work, we have given you the windows. If you require for a short period, if you receive some order for the exporting any material, all drafting we did it keeping all the concerns of the employer, that let me tell you this much only. Okay. Simultaneously, the tripartite board has been removed. Now there will be a designated authority. If at all any question comes, that will be decided by that designated authority by the appropriate government. So nothing to panic about that. Whatever system is going on, only thing is your documentations and all should be proper. And we all are aware, we are moving towards the developed nation. We need employers flexibility, but simultaneously we have taken care ease of living the life also.
Yeah.
So wherever it was required, we have taken care. Now I will tell you, friends, why I told you that you need not do panic, because for the contract labor, health, safety, and welfare provisions rules will be drafted by central government only. Again, I am taking you to section 53. The welfare facilities will be provided by the principal employer only, like drinking water, latrine, urinals, canteen. Threshold of canteen has been reduced from a different scale to 100, and that includes contract labor. And if you read the section 23 and 24, for threshold purpose we have used the word worker. For the availing facility purpose we have used the word employee. So one has to read very carefully. While drafting the rule also in the ministry, I was known, in fact, very lighter way of friends. Okay, now Minasa will teach what is the difference between the worker and employee. So
No, I think that's a story, very, and the rationale why this change has come and what's the story behind it, and you articulated it in a very subtle way, sir. My last question before we conclude, uh, as you know, on leave encashment, earlier the leave encashment happened only at the time of leaving the job, at the time of full and final settlement. But a change has come that if a person has more than 30 days, he cannot carry forward those leaves that has to be encashed year on year basis. So, is there any transition period where the employer will be given up?
this I will tell you. Okay,
Yeah.
see, while drafting also, there were different provisions in the different law. I don't have much time to explain you. Factories Act has one provision, Mines Act another, plantation, uh, working journalist, senior worker, etc., etc. So now there were different provisions. For example, the employee want to avail the leave, and when employer has not granted leave to him, then he will encash. So this provision has come that carry forward, because if you are accumulating, then also you have to run the industry also.
Yeah.
So encashment is, you have to read it again, where the employer has denied the employee for taking earned leave. Okay. Again, the wage question and everything is there. So friends, let me tell you, taking questions on 4 courts and concluding the session in 15 minutes or half an hour is no justification. Let me confess honestly to the entire audience.
Nana sir, I think you will be amazed that we've overshoot by 15 minutes. We have more than 1,500 people joining us today.
Ji.
But still, we have 900 people with us. Even we have overshoot by 15 minutes because to hear you, sir. Now, your last words that when the rules by center and state will get notified, any guidance on that, and roadmap for organization for smooth transition to new labor codes, so that people should get ready. Your concluding remarks before we close the session. And you rightly said it's no winner that in 1 hour you can learn everything. We'll have more sessions depending upon your availability in the coming days, especially when the rules by center and states are notified.
Correct. So, friends, codes you have studied, draft rules were in public domain, so you must have studied, otherwise you started. Central rules are again coming. States also, almost all the states have, except 2-3 states, all have draft rules in public domain. And so that you kindly go through it. Once all the rules are notified for implementation, things will be very clear, but we should prepare the welfare facilities or the benefits which are coming from the code shall have a bearing depending on the provisions in the rules from the 21st. So that is very clear, and it is not only to ease of doing business, but it is ease of living of the employees also. We have balanced it. If you read it, the provisions by provisions, you will come to know wherever we have given the windows to you for interpret the law in a very flexible way or liberal way. This much only I can tell you, because I cannot cite you the examples and all, but we have make it like section for prohibition of contract labor. If you read it, at least 5 times you should read it. Then you will know what is exactly written in that. I'm not underestimating the IQ or your knowledge and everything, but let me tell you, because we have taken care, each provision has taken weeks time to finalize the word in the code, what to come, what not to come. And we were, let me share with you, we were the court committee members, one secretary sir was there, joint secretary myself. We have a one conviction, even in the midnight also you are getting some thought, put it in the WhatsApp and then sleep. Next day we will discuss it. So that we should not miss out. So the journey was like that, friends. There were 14 hours, 15 hours every day. There was no COVID. The day lockdown was declared, we were in the office till 9 o'clock. So, and thereafter, I don't remember for 2 years whether there was any Saturday or Sunday. So friends, but the nation was waiting for it, and hopefully employers will get a lot of relief from the new labor codes. Simultaneously, employees will also get benefit. I told you that I'm concluding, minimum wages will be across. Floor wages से कम कोई state government नहीं दे पाएगा. Social security for the unorganized worker, social security for the gig and platform workers, and the other benefits for the regular employees. Thank you very much.
Thank you very much, sir, for your time and detailed guidance by you and our speakers, Ankur and Ashli, on various topics which will help organization to comply with the law and get ready. And you rightly said the kind of hard work and everything, you can see the reaction of the people yourself. People are very happy to hear you.
Yeah.
And as we promised, we would come out with more such session with sir once the rules are notified. We are taking this promise with you on record in the public platform. And thank you very much, sir. Thanks to all the audience for their patience hearing. We have a lot of questions. I think more than 100 questions with us. We'll respond. We have your email IDs. We'll respond to you and we'll send this recording and the presentation to everyone. Thanks once again. Have a nice evening. Looking forward to successful implementation of this new labor code.
Right. Thank you very much.
Thank you very much, sir. Thank you.
Thank you.